Hey y'all, Loud Little Ducky here. We are going to talk about Gingras and what he has to say about his failed appeal because he just says words. But let's jump right in. Owens v. Echard, fourth quarter, here we come. First of all, that is not a proper sports reference, sir, because the case would be the entire game and the hearing would be the end of the game. And then going to the appeals court would be overtime, or it would be considered the playoffs, which you lost the game and you did not make it to the playoffs. And if you were a wild card, you also lost that position. But we're not in the fourth quarter anymore. But you're not in the ninth inning. You're in none of those. But David Gingras writes this on March 29th, 2025. Ugh. So we're back to the effing blog. Yeah, it's Saturday afternoon. I'm not ready to post a video, and the word limit on Twitter is impossible. So you get this. Yay. No, thank you, kind sir. You're too kind. Don't worry, I'll try to keep this short. Sarcasm. Joke, lol, lol. Sick. Just kidding. At least I'm not the only one having a rough week. LOL. Okay. Like he thinks he's funny. He's he's not funny. Like whoever has been laughing at his jokes and telling him he's a funny guy, stop doing that. Because he's not. And he thinks he is, so he does this stuff. Because somebody's been lying to him. Gingras says, first, this won't shock anyone, but we're obviously extremely disappointed with the Court of Appeals decision. It's disappointing they issued this ruling without allowing us to argue our side. Sir, you had all the pages, and I believe even then some, to argue your side. Do it on the papers. And it's even more disappointing the court basically ignored all the key case cited in our brief. Maybe because they didn't pertain to what the judgment was for. Like if you cite cases, like, okay, let's say that Barney was convicted for stealing a baguette at the grocery store. And then the grocery store sued him for the cost of that baguette. And so, but then you go and cite something about Barney at a gas station. That had nothing to do with Barney stealing a baguette from the grocery store. That's a really bad example. But your cites went with things that actually weren't a part of the final judgment. That's where you're getting things wrong. So there might have been key cases if what you were talking about was an actual thing. It's one thing to discuss my legal arguments and the cases I think are helpful, and then carefully and thoughtfully explain why those cases are wrong and or why they don't apply. It's another thing entirely to simply pretend legal authority doesn't exist. Legal authority exists in certain things. Like, yes, there's a safe harbor in Rule 26. But since nothing was done in Rule 26, it doesn't matter. If Judge Cannoni did say, I give these attorneys' fees under Rule 26, then you would have a case. But not Judge Cannoni. Oh my gosh, I am so sorry, Judge Mata. Oh my God, I did not mean to dish you like that. Judge Mata is no Judge Cannoni. Until I've been covering the Reed case. Judge Mata didn't rule under that. So therefore it's a moot point. You would do very well in moot court. But that's what happened here. I cited plenty of legal authority for the idea that a Rule 11 or Rule 26 violation cannot be punished under other authority because doing so wrongfully strips the safe harbor from the rule. You had an idea. Ideas are not based in fact or law. And until the idea becomes a law or a fact, there is no legal authority for your idea. You live in a land of make-believe with your ideas. It's great to have dreams, but they are not there to decide your dreams. Did the Court of Appeals mention even a single one of my cases? Nope, not a single one. It just pretended those cases don't exist. Okay, cool. Okay, so you're butthurt, and crying. Wipe your eyes with the shit on the toilet paper you just used to wipe your ass with. Oh my God. They didn't even take notice. They didn't even mention my cases I cited. They just act like they don't exist. They don't exist in this appeal because they're only looking at the appeal from what was actually decided. Your stuff wasn't decided on like that. I also cited plenty of cases which stand for the idea, once again, an idea, that structural error applies in family court, and that harmless error does not apply to a judge who considers evidence outside of court, as occurred here. And if you have listened to me talk about structural error versus harmless error, I describe it as a framework of a house. And she was not there to determine whether Owens went to Planned Parenthood or not. If that was what the case is that Clayton said she never went to Planned Parenthood and that's how I know she lied. That is not what we have in front of us. So therefore, it didn't have anything to do with it because if you can take out that one thing and the case still stands with the same ruling, it was harmless. It would be structural if you took that out and the whole thing fell apart because of it. But we don't have that here. And as a lawyer with 20 years of experience, I would think you would know that. Did the Court of Appeals mention even a single one of my cases and thoughtfully demonstrate why those authorities should apply here? Nope. Yet again, it just pretended those inconvenient cases don't exist. They don't need to thoughtfully demonstrate why those authorities shouldn't apply here. They're not going to waste their breath on nonsense that doesn't apply. Like you keep wasting your breath on this Rule 26 nonsense. This isn't my first rodeo. Are you sure? It sure seems like it. You don't sound like an attorney that's been working for 20 years. And I've had similar things happen in other appeals. It's unfortunate, but it's part of the job. I'm Am I so angry? Nope. Disappointed but steadfast and resolute. Justice will come eventually. Sir, it's already come, and it's not for your client. It's to the rightful it's for the rightful participant in this lawsuit. And it's not going to come for her in this case. So what's next? Simple. We keep going. We have at least 3 options left. We can ask the Court of Appeals to reconsider. That's going to be a wasted breath once again. This request must be made within 15 days from the date of the decision, but these types of requests are rarely granted. Still, it couldn't hurt, so we might use this option. Haven't decided yet. Why are you working for free for this woman? Why are you ruining your career and possibly losing your law license over this woman? She is not worth this. Like, no client of mine is worth me losing my license over. And I don't have a law license. 2, we can ask the Arizona Supreme Court to grant review. This is discretionary, meaning they don't have to hear our case, and they probably won't. They can just deny review, which means the Court of Appeals ruling stands, which also means Mata's ruling stands, the original ruling. I don't see Arizona Supreme Court taking it. I don't see the Court of Appeals reconsidering anything. We might have a Jeanette Braun situation here. If you don't know about Janet or Jeanette, you can look at Cece Suarez. You can look at Ian Runkle. They have gone over Janet or Jeanette Braun, internet lawyer. Laura the mortician. That's a crazy scandal. She's crazy too. Her and Gingras would probably get along very well. She said the process starts with a petition for review, which is relatively short, word limit only 3,500 words compared to the 14,000 for the opening appeal brief. So the petition is really just a summary of why review should be granted. It's not a full discussion of the law. I don't know how you're going to get to sum this up in 3,500 words when you had to ask for extra pages in your appeal. But okay. Like, go on with your bad self if you want to do this. Like, nobody's stopping you. We're just going to be here later saying, I told you so. The petition is due either 30 days from the appellate court decision or 15 days after the reconsideration is denied, if reconsideration is sought. So that is telling us within the next 30 days, we will know which avenue they're going for. And we'll look at that when it comes out. While we may or may not ask for reconsideration from the lower appellate court, we are 100% going to seek review from the Arizona Supreme Court. No question. If the court grants review, we then get to submit more detailed briefs similar to what was done in the lower appellate court, and we can ask again for oral argument. I don't think they have to hear your oral arguments either. 3, if the Arizona Supreme Court denies review, we are still not done. Last stop is the United States Supreme Court. While it may sound crazy for a simple little paternity case to go that far, this sort of thing does happen. In fact, here's a recent example from a case called Smith v. Arizona. We're going to look at that case. In Smith v. Arizona, the defendant was convicted of drug possession in Arizona State Court. He raised a minor technical legal argument, which the trial judge rejected. Then he appealed to the Arizona Court of Appeals, where he lost. He then asked the Arizona Supreme Court to grant the review, but he lost again. They didn't even hear his appeal. So this is what he's saying can happen. That they can lose, and then they can still win at the U.S. Supreme Court. I don't think that the position that Owens is in is the same as the Smith v. Arizona. And let's look at why. And just by the way, I am so mad that Casetext was bought out. And so now I can't use Casetext because they're with like Westlaw and Thomson Reuters or whatever it's called. And so therefore there's like, I couldn't get the stuff for free. I found another place that at least gave us a summary, but I'm really mad Casetext is gone. But Smith v. Arizona, CO2 US 2024. So it is very recent. The summary is the case involves the Sixth Amendment Confrontation Clause, which guarantees a criminal defendant the right to confront the witness against him. So just in that first sentence, we are standing in a very different circumstance than Owens is standing under. One, it's not a criminal case. It's a family law case. And Gingras cites a lot of criminal case. But criminal, civil, and family court are all different. They all have the different set of laws that fall under it. Yes, we all still have our constitutional rights and things like this. But things are different. And so none of Owens' constitutional rights have been messed with in this case. She's also not being charged with the crime as of now. We can hope one day she will be, Rachel Mitchell. But, so we're already in different standing. But, okay. So, in this case, the defendant, Jason Smith, was charged with various drug offenses after law enforcement officers found him with large quantity of what appeared to be drugs and drug-related items. The items were seized and sent to the crime lab for scientific analysis. Analyst Elizabeth Rast ran forensic tests on the items and concluded that they contain usable quantities of meth, marijuana, and cannabis. Rast prepared a set of typed notes and a signed report about testing. However, Rast stopped working at the lab prior to trial, so the state substituted another analyst, Gregory Longoni, to provide an independent opinion on the drug test performed by Rast. So we see the problem here. If Rast is the one that ran the report and the analysis and all of that, Rast has to get up there and be the one to introduce this evidence. You know, whoever did it. Now, I don't care if she did not work there anymore. You find her, you subpoena her, and you make her come to court. You don't get to substitute. If this is the one who made the report, and this is where his charges came from, because she's the one who confirmed these things, Rast needs to be the one there. Because this Gregory Longoni did not do the report. He did not test the drugs. He did nothing. He's just there to read a report. And based on what that report says, give his opinions. He has the right to confront Elizabeth Rast. Longoni has nothing to do with this, other than he was just substituted in to try to get this evidence in. So I agree, that is a huge F up by the state of Arizona. And so it says, at trial, Longoni conveyed to the jury what RAS records revealed about her testing before offering his independent opinion of each item's identity. Smith was convicted. So he did not get to confront his, witnesses or accusers. Rast was one of those accusers. And so, therefore, his Sixth Amendment was violated on constitutional grounds. Owens has no constitutional grounds that have been violated in this. And then I guess, on appeal, he argued that the state's use of a substitute expert to convey the substance of Rast materials violated the Confrontation Clause rights. The Arizona Court of Appeals rejected Smith's challenge. And then they didn't hear the court in Arizona Supreme Courts, but the U.S. Supreme Court took it and reversed it because his constitutional rights were messed up. And we have to protect a defendant's constitutional rights, especially in a criminal case. Owens is not this. It's not the same. I don't care if this is your example to say, see, he was convicted, everything was this, and then it was turned at the United States Supreme Court. Owens is not in the same position as this person. They're not the same. Smith then asked the U.S. Supreme Court to hear this case. By that point, the state of Arizona was so confident he was going to lose again. They didn't even bother filing a brief asking the Supreme Court to deny review. But guess what? The High Court took the case and ruled in favor of Smith, the guy that lost in Arizona Superior Court, lost in the Court of Appeals, lost before the Arizona Supreme Court, won at U.S. Supreme Court. Yes, in a criminal case where his constitutional rights were violated. He should have won at that level. That is not what is happening in Owens' case. Says, I just mentioned this because I know JFC thinks Clayton is won and the battle is over. JFC is wrong. Since I am not a crazy person, I will admit yesterday's ruling appears good for Clayton, but it's legally and factually incorrect, and so we keep going. Well, nothing you say is based in law or fact. They are make-believes and doctored evidence. In closing, let me just remind JFC the fact pattern of our case is basically identical to a case cited in our briefs called Marchese v. Abersold. In that case, a family law judge conducted her own independent research into the criminal history of a man facing an order of protection hearing. No one argued that anything the judge found was wrong. No one argued the criminal history found by the judge wasn't accurate. Instead, Marchese argued the judge broke the law simply by investigating the facts on her own, something all judges are strictly forbidden from doing. We've found case where it was allowed. I believe at the Supreme Court level. But let's take a look at this case that's so similar. Let's look at Marchese. All right, so Marchese v. Abersold. The Supreme Court vacated the issuance of a domestic violence order and remanded this case for additional proceedings, holding that the trial court's receipt of extrajudicial evidence was structural error, and that the trial court's use of extrajudicial evidence from an undisclosed source was improper. Plaintiff petitioned the family court for a DVO against the defendant. The trial judge granted the DVO. Defendant appealed, challenging the trial court's extrajudicial research concerning his criminal record. The Court of Appeals affirmed, holding that the trial court committed an error in conducting the extrajudicial investigation, but the error was harmless. That's what they said. That's what the trial court said. The Supreme Court reversed, holding that the trial judge's undertaking to obtain and use as evidence extrajudicial information relating to a party in the case caused her disqualification from a proceeding further as the presiding judge, and her failure to recuse was structural error undermining the integrity of the resulting DVO. Okay, so we have our house for this case, right? It is, in this case, did this person do domestic violence here? And so in the house should be all the evidence that proves and shows that the defendant caused domestic violence, whether it's photos of the abuse, videos, medical reports, all that is in the house, right? And so, and you're basing an order off of that. And based on the person saying, he beats me or whatever he does. So that's our house and all the evidence inside. What this judge did, instead of giving the DVO out on this house and what's going on inside, she issued the DVO because he has prior criminal acts. So maybe he has past domestic violence things. And so because he committed domestic violence prior, that's why she issued the DVO. She didn't issue it because of what was going on in this case. So the framework of did he commit violence in this case is the beams have been knocked over because they went next door and issued it based on what next door said in that house, which is not the same house we're in. I hope that makes sense. I'm trying to dumb it down. Y'all probably know what it means anyways, but I agree. It's it's issuing that, you should issue it because of what's going on here. Because there are women who, let's say Owens. Owens, just goes and gets orders on all these people. And so let's use Greg for example, or let's use Clayton, okay? If another woman went to go get an order of protection from Clayton, they would need to look at, did Clayton abuse that woman? And issue an order of protection based on Clayton's interaction with that girl. What the judge cannot do is go look and be like, oh, well, you had one against Owens, so you must be doing it here. That's not allowed. Once again, we are not in the same place as what is happening in Owens' judgment. I don't care what he says. The two are not the same once again. After the trial judge ruled against him, Mr. Marchese appealed to the Kentucky Court of Appeals. If you want to read their decision, here it is. Marchese lost in the lower appellate court for the exact same reason Laura did. The Court of Appeals agreed the judge did something improper, but said it was harmless error. Was the correct standard of review and concurred the error was harmless. Therefore, Mr. Marchese lost. This is exactly what happened in our case. But Mr. Marchese didn't give up. He asked the Kentucky Supreme Court to review the case, and they took the case. The court then unanimously reversed, holding this type of judicial misconduct is always prejudicial, and thus is not evaluated under the harmless error standard. So again, just like Smith v. Arizona, Mr. Marchese lost in the trial court, he lost in the Court of Appeals, but he won in the state Supreme Court. So that is what he's using as reference. I don't think it's going to be the same thing. Even if Arizona Supreme Court takes the case, I don't see them siding with Gingras on this. I mean, we could all be shocked. And he might be rubbing in our face and saying, I told you so. I don't know. I don't think so, but the clock's right twice a day. That is what I fully expect will happen here. Think about it. If Kentucky Supreme Court's decision in Marchese's was legally wrong, why did the Arizona Court of Appeals not even mention it here? There is not a single word of analysis or discussion of Marchese in our decision, and spare me the BS about how Kentucky court's decision is not controlling in courts in Arizona. That's true, but structural error is a rule to be taken from due process clause of the 14th Amendment, and that the part of the Constitution is absolutely controlling law in Arizona. Obviously, the Arizona court couldn't explain why Marchese was wrong because it was not wrong. And I expect the Arizona Supreme Court will thus do exactly what Kentucky Supreme Court did, which means Laura wins. But if the Arizona Supreme Court disagrees, that only helps our chances with the U.S. Supreme Court, because as rare as it is to have them take a case, they are much more likely to accept review when different courts have issued conflicting decisions on the same legal issue. We will see. We shall see. A couple of final comments. No, I still haven't heard anything from the Arizona bar. Last contact with them was months ago. I never received the decision from the Judicial Conduct Commission when my complaint against Motto was dismissed. I don't know why he says he hasn't received it. He should have received it. They said they sent it to him. He at least knows about part of it, just like we do. But it should be sent to him. I don't know if he's lying about this or what. The first time I learned about the dismissal was when JFC tweeted about it in late February, I think around February 21st. Obviously, without seeing the evidence the commission considered, I have no way of knowing whether their decision was correct or not. That's why I've asked them to provide me a copy of MATA's response, which the rule says they can choose to give me or they can choose to withhold it. If the commission chooses to withhold the information, we are looking at the option of taking legal action to force them to disclose it. That action, if we choose to go down that road, would be based on the same legal standard theory discussed in this case, Civil Rights Corp v. LaSalle. He should get the information. I agree with him there. If somebody's going to make a complaint, you should get that complaint and the stuff that went with it. The page said, it said, oh, we only publish like the first 5 pages. If you want the rest, then you have to like request it or whatever. So he requests them, he should get them, all of that. And this case that he cites to me does match up with what he's saying in regards to this. It is a very similar thing. So he shouldn't be denied being able to look at, the complaint. He says, how's Laura's feeling? She asked me to report that she's extremely confident. Well, that's because she has somebody gaslighting her. And feeling good about the plan moving forward. Well, good for her. Okay. Says, no, not just anyone can argue before the Supreme Court. You must be a lawyer, admitted to the Supreme Court bar, and the case must have been accepted for review by the court. So these are a few things that Gingras is going to have to overcome. So he's going to need a Supreme Court bar membership, which I do not believe he has. And so he has to be admitted to practice. He probably has to be in good standing, and everything like that. So that's one hurdle. Then case selection. It says even if you're a member, so even if he becomes a member or is already one, you can only argue a case if the Supreme Court accepts it for review, which is highly selective process. In the live I did, we talked about some of the things that they took according to family law. Somebody can be self-represented. Sorry, my grandson just got home. Oral arguments, once in the case is accepted, the lawyers representing parties for the parties themselves, if self-represented, are given time to present their arguments to the justices. So I guess in the U.S. Supreme Court, it's an automatic oral arguments. Then it talks about the Solicitor General, and then public access. Oral arguments are open to the public, but seating is limited. So those are just some of the things that Gingras has to overcome. But that is it for Gingras's blog. Like, subscribe, turn those notification bells on, and I will talk to you later. Bye.